OSHA update on workplace violence prevention for general industry, non-healthcare settings, presented by our sponsor, Heffernan. We're so happy you could join us today. My name is Michelle Wilcox, and I will be your moderator. I will also be monitoring questions you may have during the session. Before we open up the session, let's review a couple of key items. All of the webinar materials we discussed can be found at the URL currently showing on your screen. I will be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. We do not control the audio devices. Your device controls the audio. So if you have audio difficulties, try adjusting the volume settings on your device. Or if a telephone line goes down during the call, hang up and call back again to the same number. If all lines go dead, watch the on-screen question box for an alternative call-in number. Feel free to ask questions or provide feedback by using the questions box during the webinar. If you're using a tablet, you may need to tap on the screen for the options bar to appear. Then you can select the appropriate option. We may not respond immediately, but we will work your questions or feedback into the presentation. If we can't get to your comment or question during the session, we will be online afterwards to respond, or we may follow up in an email if we run completely out of time. You may also email us at moderator@aspenrmg.com for up to 48 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged throughout, and the presenter will be answering questions throughout the presentation. With that, let's begin. Our presenter today is Steve Thompson. Steve founded Aspen Risk Management Group, now part of TriStar, where the Aspen team is dedicated to saving lives, preventing injuries and illnesses, and protecting clients from harm. Since 2005, they have helped over 9,500 organizations and 1 million people work safer. He is the co-author of Workplace Safety, a guide for small and mid-sized companies, and High Payoff Safety, coming in 2026. He attributes the success of winning the American Society of Safety Professional 2023 Safety Professional of the Year to his dedicated coworkers. Before his safety and risk career, he served as a medic in the U.S. Air Force and worked as an emergency room LVN nurse. With that, I'm going to go ahead and hand the presentation over to you, Steve.
Thank you, Michelle. It's great to be here. This is my first webinar in 2025. So if I sound a little shaky or I mess up the technicals, I'm sure everybody will be, well, accommodating. So great to be here. And yes, there are updates to the Cal-OSHA workplace violence prevention plans for general industry. Not a lot, but I thought it'd be good to talk in this webinar about that. And as Michelle mentioned, this webinar is completely interactive. That means that if you have questions, you can ask them throughout. If you have a comment, for those of you that have a lot of experience in this field and you want to make a comment or have something that you've heard in the last few days, we want to hear that. We really want you to be a part of this presentation and help make it a success. So as with many of the Aspen webinars, a couple of things on logistics. If you do have some technical issues during the webinar, you can use the chat feature, and that's either chat or questions, depending on the software that you're using, you can use. So let's begin on the California update on workplace violence prevention for general industry. And if you have questions on other industries, that's fine too. But before we start, we'd like to ask a polling question. And Michelle, can you read and launch the next polling question?
Sure. A little bit about yourself. Can you please tell us if you're directly responsible for workplace violence prevention, WVP, if you're responsible for WVP for department, division, or location, manager, supervisor, or other with WVP responsibilities, safety consultant, risk or loss control, or similar role, or other as a final option. And I appreciate everybody's voting, and we're going to give it a couple of seconds here before we go ahead and close out the poll. And Steve, I'll go ahead and we'll go ahead and give it a couple more seconds.
I know that the Heffernan audience is always pretty engaged in this process, so it's always great to see the results that come out from the polling questions.
Yeah, so it looks like 41% say they are directly responsible for workplace violence prevention. 28% say they are manager, supervisor, or other. The next 6% for both responsible for WVP for department and 6% for safety consultant. And then we have 1%, or I'm sorry, 19% as other.
Great. Well, for those of you that are in the other group, you can certainly drop a line into Michelle on the question or chat box. We always like to hear the others. So thank you, Michelle. And then if we can move on, we have a second question for everyone.
Okay, the second question here. How would you rate your workplace violence prevention knowledge relating to the California standards? We've got awesome, expert, a little more than most, on par with my peers, early stages, just getting started, or not sure. And again, I'm going to give it a couple seconds here.
And Michelle, for our awesome experts and those that are a little bit above, we'd love to hear your feedback during the session. So feel free to drop in a comment or question along the way.
Great. Okay, let's go ahead. I'm going to close and share. So it looks like 41% are on par, 26% are early stages, just getting started. We've got 22%, a little more than most, 7% not sure, and we've got 4% that are awesome experts.
Thank you, Michelle. Okay, why don't we talk a little bit about what has actually driven most of this regulation and this standard to be developed, and of course some other states are working on this too. These are the numbers for California as it relates to workplace fatalities, and then if we look down closer to violent acts. So when we break out the total of 95 violent acts that caused fatality in California, 53 were homicides, 44 shootings, 9 other causes, and then suicides and broken out by its particulars. Suicides are included. You would say to yourself, well, why is a suicide included in a workplace fatality when the workplace probably didn't cause it? Because suicides that happen at work are counted under the fatalities, even though they've occurred at work, and they may not be related to work, and of course very rarely compensable unless they're in certain circumstances. So these are cited under workplace violence and in there. Now, you may have not seen these numbers before, so it does give rise to thinking about mental health and the other issues associated with suicide versus just dealing with pure workplace violence and the four root descriptions of what workplace violence is in the workplace. As it relates to where this happens, you can see that most of this is in the retail service, or of course in security or protective, sort of in law enforcement. There are remote worker cases, and then of course domestic disputes that spill into the workplace. These are, at least in 2023, which is the last statistics that we have, in 24 looks very similar, but of course you could have a mass shooting at work or something like that that could drive these statistics a little bit differently. But in 2023, these are the numbers that we had. As it relates to suicides, there's a couple of things that you may want to give some consideration of, and the impact, of course, is real. It's coworkers, witnesses. You can have morale issues when a suicide occurs at work. It can really shake, a workplace culture. It's good to have a mental health support. These are things like EAPs, employee assistance plans, even peer support, making sure that supervisors have been, trained to spot distress, and make sure that people know where they can refer, individuals, whether it's a healthcare plan or it's an EAP plan. And what do you do after an incident? Do you have a crisis communication and plan to deal with these kinds of events? And suicide should be part of your discussions. And there were some increases of events that occurred. We talked about this before, and the locations of where they mostly occur. And again, these are the elevated risk for 2023. And by the way, this presentation will be available to everyone along with all of the handouts that we'll go through today also. And where does this apply? As you can see, that there are some exemptions to the workplace violence regulation for general industry, and it applies to all employers and employees, including where there's provided housing, except for these locations. Of course, there is a separate standard for healthcare. I think most of you know that. There is a separate. It doesn't apply to corrections or rehab or law enforcement as long as the organization, matches up with the standards that are listed here. And then employees that are teleworking from a location of the employee's choice, not under the employer, is also an exemption. And then a very odd one, which we'll talk about in a little bit, is the less than 10 employees that don't have access to the public. But let's really talk about how OSHA is talking about that and what the new standards board is putting that into practice. Okay. We have another polling question. So Michelle, do you mind launching that for us?
I don't mind at all. Question is, how would you rank workplace violence as a threat to your organization? Minimal threat, low threat, moderate threat, high threat, or critical threat? And give it a couple seconds here. Those statistics actually are quite surprising, Steve, in terms of
I don't think we've talked before about the differences between homicide and suicide, and I don't think we've, fully expanded on the locations, but the stats are out there now.
Gotcha. Okay, I'm going to go ahead and we're going to close the poll. Looks like majority has said low threat. 35%. That's 35% of low threat. 27% minimal. 26% moderate. 8% high, and 4% critical.
Great, thank you. And for those of you that are here today and this is a minimal or a low threat, we understand that perhaps you're here really to get an understanding of the, let me just release this thing that's on my screen. You're here to get an understanding of the regulation, but also any updates that have occurred in that particular process. All right. This you should remember from a prior presentation, or for those of you that have plans already, what the types of violence are and as they're classified under California law. And these are the FBI classifications, especially type 4. But you can see that the first one is, this is, of course, that was part of the original regulation, which is SB 553, committed by persons who have no legitimate business at the workplace. This could be someone who just comes to the workplace, creates a violent act, and is intent on committing a crime. The second one is directed at at employees, generally by a customer or a patron. Let's say you're a city, county, or something like that. These could be patrons of the city. It could be at an office where they're paying their water bill or something along those lines. It could be in a prison where they're inmates. It could be a school. It could be in a hospital. It could be in a clinic that's not under the healthcare standard, where you have patients. So any classification where somebody's related to the business as they are doing business with them. Number 3 is against an employee or present by a former employee or an existing employee, a supervisor or a manager. So those are the cases where you see an employee, versus another employee or an employee that used to work there come into the workplace. And then type 4, which was added later on, even in the original standard of the healthcare standard, type 4 was not listed, but this is where a person who doesn't work there but has or is known to have had a personal relationship with an employee. These are usually domestic issues where there may be a spouse, a boyfriend, somebody of that nature that comes into the workplace. They not only do they bring a threat to the individual that works there because of their relationship, but it also could mean a threat to others that are in the workplace aside from that. And of course, there are methodologies part of this, which is what are the updates? Most of you know that the standard was signed in 2023, and then it became, law by July 1st, 2024, to have an actual workplace violence prevention plan into place. And that meant getting your training done, getting your logs, created, writing the plan, having someone responsible, all the factors that go into the existing plan. There was also a secondary part to the workplace violence prevention program that was written, and that was SB 428. This went into place in January of 2025. And this allowed employers to seek workplace violence TROs, or we call them temporary restraining orders, to cover certain issues like harassment. We've never had that before. We're the only state that actually has the ability to do a restraining order against someone that's harassing. It's always been a violence, but never harassment. So this took place in January of 2025. Now, Cal OSHA has been directed, of course, to begin the finalization of this SB 553. They're still citing based on, general industry, but there is a standard that's being created. So there have been some major revisions that happened just in May, and then all of the public comments closed in July. By the end of the year, Cal OSHA is required to complete the standard. And what we discussed today will probably be very close to what the standard will look like. The changes we'll talk about are probably going to be, part of the final regulation. And then in 2026, December of 2026, the standards board will adopt the final standard. So you have some way to go before we get to the final standard. And it's tough for employers, I know. For all of you, you're writing these plans. You based it on a Senate bill. You don't even really have a standard to go by because it doesn't exist yet, and you're just hoping that you've done the legwork and your homework to be able to get this plan written so that it's in compliance. So that's a little bit about what the updates and the background is as we go forward. So one of the things that was part of the update was the issue of determining. A lot of employers thought that if they had less than 10 employees, then that this standard doesn't apply. And that's not the way the intent was. It was if they had a small number of employees, less than 10, and then no direct public contact by any employee. Now that really doesn't make sense because they give examples in Cal OSHA. A warehouse with 8 staff, no customers may be exempt. A coffee shop with 6 staff serving customers is covered. But a person working in a warehouse faces what? They face potential domestic violence. They face the potential for a supervisor or another employee. They face other aspects of, dealing with the public. And then they gave an example of an accounting firm where everybody's behind the scenes and they're only doing accounting work. Well, maybe they're talking to people over the phone. Maybe they're working in an environment where one employee has violence against another. So I don't think they've really thought through this very clearly. I know they were saying they were trying to give a break to small employers, but it doesn't really make sense if you're really trying to prevent. If you do have less than 10 employees, I would give serious thought to really looking at the 4 classifications of workplace violence. And if an employee has no chance of being involved in any of those 4 classifications, maybe you'd be considered exempt. The worst thing you could do is, have a plan, even if you think you're exempt, have a plan in place, because if something does happen to one of your employees, you'd rather be prepared rather to be unprepared. So that's one of the changes that happened. It must be both. You must have fewer than 10 employees, and they must have no direct public. That doesn't mean if you have 100 employees and no direct contact that you're exempt. You have to have fewer. Change. Yes, go ahead.
I'm sorry, you just cut out a little bit.
Oh, how am I? Back in? Am I back?
You're back. It's happened twice now, but I'll just keep you, informed. But one question with regard to somebody wanted to know, would a landscape company under 5 employees working residential be considered exempt?
I wouldn't exempt that because they're the public that they could be engaged with.
Gotcha. Okay.
Yeah,
For the interruption. You're
I'll
good.
try to go slower. The other thing that changed is the confrontation language. There was a blanket ban on confrontation. Now, I know the policies that we wrote didn't put this in there because we knew that, of course, security, police, others, you have to have a methodology in some cases to deal with crime. And in this case, the original plan was written that no employee will be able to confront someone like a shoplifter or someone committing a crime. But now it's changed that trained individuals, those like security or others that have been trained in either de-escalation or circumstances where, you know, they may not just de-escalation, but what to do in the case of a crime happening. But other employees now are just to do the three things: observe, report, and disengage, not to become involved. And employees are protected from retaliation for lawful self-defense. This was part of the plan before, but it's more clear now that if an employee has to defend themselves, that there can be no retaliation against them. So this is how it's today, and that's the change that occurred. The other thing that changed is that there were limited ways to report workplace violence cases in the original legislation. Now, for those of you that have built your plans, you probably already built in numerous methodologies for communication, whether you had you used a digital format online, you had a paper method, you had a suggestion box type of methodology. I'm sure a number of you had multiple ways to report a workplace violence incident or a threat of workplace violence. And it's only solidified now in the updates that talk about there has to be a methodology if the supervisor, of course, is creating the actual workplace violence against an employee. You have to have a way that they can bypass the supervisor. Why would you go to your supervisor if they're the ones committing the, you know, the workplace violence or the threat against a particular individual? So these are the types of changes as it relates to reporting that were put into place. And this, you can either, you know, this is what you generally have to have as part of your reporting piece. Most companies developed an incident reporting procedure already, and they have a form to describe what occurred. But if you don't, these are the types of things that now have to be included. They just couldn't, there were some, Cal OSHA was concerned that some reporting was just being, oh, I had a workplace violence incident or a threat, and no details, when it occurred, how it occurred, who was involved, what was the type of violence. These are the things that now are required as part of the reporting process so that an investigation can then be done, and then a determination on whether or not there was actual violence or a threat of violence. In investigations that happen after the threat or after the violent event, I'm going to share with everyone a violent incident investigation form. And Michelle, you're going to do what with those again?
I will be sending a follow-up email with a link, and I'll be uploading those to the Heffernan website, and I'll include that in a follow-up email thanking all of you for attending. And if you have any other questions that you may think about in the future or that comes to mind afterwards, feel free to shoot us an email, and I'll relay those to Steve for his response.
That's great, thank you. So in post-incident investigations, it is important to identify, you know, those involved. Now, there are some rules relating to your violent incident log, which we'll talk about in a few moments, and we'll talk about the details of that. But you can't leave out these factors when it comes to doing your investigation. you have to determine the contributing factors. You should be able to determine the type of violence that occurred. It might be multiple types, but you should really be able to determine that. You also have to discuss what corrective actions were taken. And that, as you recall, in workplace violence, these can be corrective actions with employees. They can be corrective actions to a facility. Perhaps there needs to be some changes to the building. Maybe you know, you're in a particular environment where you want to put in some sort of protective barriers in the front of the building, or a locked door, or elevate your, you know, your service staff that are, you know, that are on the front lines, or have, you know, buttons, emergency panic buttons. So, you know, corrective actions are not just about telling employees or training employees about a process. It's also about making changes to your organization. And then, do these things work? You know, have you tested them? Do you do a review of your plan every year? Do you do, you know, a drill, or do you do some practice tabletops that show that this is an effective means to prevent workplace violence? The other thing that's happened is the multi-employer coordination. This was left as a big gap in the original regulation. It really wasn't discussed. And I still think it's a bit squishy at this point in time, because it doesn't define which employer is to do what. It really describes the process that says, if you have a multi-employer work site, let's say, for instance, that you do have a janitorial contractor and a building manager, and they've got to agree on a few things, like who's going to train the staff, where do the reports go, who investigates incidents. And generally, the best practice is to have some sort of written agreement or a memorandum or memo of understanding between the organizations that are sharing a workplace. So this is still not really well defined at this stage. I suspect it will undergo a bit more, massaging before we get there. But right now, the way that it stands is that the employers that are sharing the work environment are to come together and, make a decision on who does what. Now, if you follow other multi-employer plans for, say, in the construction industry, you already have a clear path on how things are to be done. But in this particular case, they left it open. They haven't closed the loop on it as of yet. And what we're going to provide you is an outline of how to coordinate with other employers, so that we're giving it our best guess on what this is going to look like in the end, based on what we see so far and based on what the industry already does for multi-employer coordination. And therefore, you'll be in good shape to be able to, if you've not already integrated this into your plan, then you'll be able to do it now. So I want to make a technical note here of why we've put this in red. The violent incident log and investigations are to be retained for 5 years. This is the updated version of when this, how long you have to keep this. I'll circle back around that in a moment, because there's a nuance to that retaining for 5 years. Training records. Now, there's a lot of companies that I've worked with over the years, and maybe you feel this way too, and it's okay, that you want to retain your training records for longer than a year, because it'll help protect you in the cases of in cases of a Cal OSHA violation or otherwise, and say, well, yeah, we trained this person. See, we have 2 years of records, blah, blah, blah. Here's the problem with keeping your records longer than what Cal OSHA is recommending. What if you had a group of employees, say 100 of them, and you missed one employee that trained, and it was 1.5 years ago? Well, if you get rid of the records, or you don't show the records when they're requested, and you go back 2 years and they find that there are people missing from the training, that can be problematic. It can be a liability. So generally, we recommend that you keep them for the minimum period of time for sharing, whether they be subpoenaed or whether they be part of a Cal OSHA investigation or citation or otherwise, because the possibility of you having a mistake or missing something that goes back further in a year, it's possible. And why expose yourself to that? But again, you may have the feeling that, listen, we have an electronic process. We do all the training. We don't miss anybody. No one's sick. No one's on vacation. Everybody gets done. So there are no gaps at all in our training. It's all done correctly. Great. You can retain your training records as long as you like. But it's just important to be aware that you don't want to expose yourself to something that you don't need to. Because remember, when you have a Cal OSHA citation or otherwise, you should be providing the bare minimum that's requested. Never provide anything more than what's asked, even though you think it may help your defense and this and that. It only can lead to problems because it allows another avenue of discovery. And we'll talk about this in a moment. It's the same way when you submit a photo to Cal OSHA, when you've had them walk through and say, we want photos of this or that. You've got to be really careful to make sure that it's the exact photo of what you're looking to send them, and then nothing in the background reveals a hazard. So you've got to be very cautious about that. And that's why we put this in red here with the training records. Just want to be protecting of that. The other thing that was changed in the in the updates in May was that there was this assumption made that employers are responsible for social media, and that if an employee is let's say they're being harassed, let's say that they're being threatened on social media, but the employee doesn't tell their boss or otherwise, and they're being threatened by another employee, or they're being threatened in some way that's related to work. Well, there was this thinking that employers should have some responsibility to have this involved, like it could be a Glassdoor, or it could be LinkedIn, a professional site, not necessarily Facebook or Instagram or anything else, but more in the professional environment. But the board came out and said, no, we're not going to make employers responsible to monitor any social media, whether it's professional or not. But if you are made aware of a social media threat against one of your employees, then you should investigate. So it has to be treated differently if you're made aware. And that's the difference in what was originally thought before. Now, the plans, I know that our team and others were probably writing back then, left this more open because it didn't make sense that an employer would have to monitor social media channels of all their employees. As a matter of fact, that seemed contrary to privacy. But regardless, it's been spelled out now, and so that's one of the things that we'll be happy about. Now, a summary of the draft. Let's just see what the updates have been since the original standard came out. Remember, the exemptions narrowed, although there are very few employers that are truly exempt. If you really if you really think about all the methods of workplace violence, all 4 of them, then really it's almost no employees would be exempt and no employers. So I just challenge all of you to think through the public exposure or the exposure to workplace violence that your employees could have, even if they're only dealing with people on Zoom calls or phone calls or otherwise. Confrontation delimited to trained and security roles. Remember that standard now says that those of you that have training in security or de-escalation or otherwise, you can approach workplace violence differently than general employees without the training. And then as we go down the list, remember, there's a bypass now for supervisors. You've got to really do investigations in a structured format. And by the way, Michelle will include a very well-structured workplace violence incident investigation form that you can use if you don't have one already, that covers all of the details of the standard and the new aspects. And then this coordination of duties, longer retention of records, 5 years versus 3. That was a question mark before. And then digital threats only need to be covered when you're made aware of them. Let's talk a little bit about 428. And we talked a little bit about this earlier, but I do want to make sure that we mention this because this became law in January of 2025. And these are the types of things now that should be included in your workplace violence prevention plan. And the reason why this is part of the workplace violence prevention plan is because this is a methodology. Remember, we talked earlier about various methods and steps that you can take to protect your workforce. That is your goal, that's your role when employees face the potential for workplace violence. So in this particular case, you have the chance, if necessary, to file a restraining order. And employers have had this right for a long time. This is something that, you know, if you have a restaurant or you have you know, people who are coming in and threatening your employees on a regular basis. Let's say there's a person that's, you know, homeless and they are, you know, coming frequently and causing disruptions and threatening violence against your employees. You can file a restraining order against them. But what's changed in this legislation is a couple things, and we'll go through that. So this is, again, not in Cal OSHA, but it's part of a civil process. So employers can file, they've always had the authority to file, but the collective bargaining representatives can file if they represent employees, but union reps cannot file without an employee's authorization. So even if you are a non-union shop, an employee, if they designate a union representative, they can also file. It's not an avenue for a union to come into an operation. It's not structured so that union reps can work their way into an organization, a non-union organization, to help protect employees. But it can happen in certain circumstances. So these are the particulars of who can file these TROs. Now, the big difference that's occurred in this, the reason why this standard came out was that there's a difference now between violence and harassment. You know, we've always we've had preventing harassment and training in California well over 15 years now, and the standard's been out that, you know, supervisors, you know, have a training class 2 hours and employees have a 1 hour training class. And employees have to be trained, of course, when they come on the job and then periodically after that. But we never had avenues to be able to take, you know, to minimize harassment other than to go through various steps in the HR process. But now harassment is included as part of a temporary restraining order, not just the actual violent event or threat of violence. Harassment is defined now under SB 428. And this is as I've spoken in my last presentation, this now becomes, you know, this can include stalking or unwanted contact or threatening behaviors. And I'll have an example here in a moment. Let's just take a look at a 65-year-old man obsessed with a 24-year-old employee. I'm just using it as an example. Please don't take any offense if you're 65 or you're 24 or anything else. This is a person who has repeatedly called the business up to 100 times a day for months, and nothing was violent, but then it escalated to threats of violence. So in many of these cases, because it's just, you know, harassment, an employer and the employee couldn't do anything about it. But now SB 428 allows an employer to act, and it allows you to file a TRO against somebody that's causing this kind of you know, aggravation against someone. Now, this may seem a little bit over the edge, but this is it for those of you that have been employers for a while, or you've been in HR, you've been in risk management, you know that this is something that can occur. Employees can harass others. There can be thwarted, you know, love engagements that can cause problems. There can be relationship issues at work. All sorts of things can happen where these types of examples can occur. So these are the actions that that are part of SB 428, and of course there are some things that are recommended. You can consult legal counsel before filing, of course, but you've got to keep track of this as much as you would anything else. And there, of course, all of the technology that you would use in your process, to integrate not only with 428, anonymous reporting apps. Do you have a methodology to report harassment or workplace violence? Do you have, check-in periods where if you have a remote worker where there is a valid check-in time? Get panic buttons where necessary in operations where, an employee may need access to something like that. And do you have a process in place to provide notification for threats? Let's say there's an active shooter or some event that's occurred in your organization. Do you have a way, if necessary, depending on your operation, to make a mass notification? Are you using Teams? Are you using some process that allows you to do that? These are things to be thinking about in your workplace violence prevention plan. And here's a couple of pre and post for 2025 versus post. After, this is pre workplace violence restraining orders, and you can see the differences between the two. I'm not going to read through them because we discussed them already, but you'll get the presentation, you'll have a chance to see them, and you'll have an understanding of what was before 2025 and what is now as part of law. Okay, another polling question for you. Michelle, do you mind launching this one?
Not at all. So the question is, our workplace violence prevention plan is, and the options are excellent, good, average, not sure, or on plan. And while we're waiting for everybody to take notes, I got a couple of questions for you, Steve.
Sure.
One attendee said that they're getting WPV reports from employees based on workplace stress or what they would consider bullying by a manager, which could be just a manager holding them accountable. How would we make it clear what is or isn't violence?
Well, a threat of violence can be the same as an actual violent event. So it doesn't have to be an actual physical confrontation. It could be the threat of violence that can also be reported. So the violence as described, and we have a sheet on that describes what a violent event could be. It could be the threat of an attack. It could be the threat of harm in some way, physical harm. It could be emotional harm. It doesn't have to just be, I'm going to take a hammer and bang your head in. If a person perceives that they're being threatened in a violent way, then it's workplace violence in their minds, and you have to classify it as that. So we have to be able to take a reasonable person and say if they perceive it. So bullying, if a person is perceiving that the bullying is a threat against them of some manner, then it is a workplace violence reportable event.
Okay, thank you.
Yep.
One other quick question. If there's an employee experiencing domestic violence outside of the workplace and has notified HR of the situation, does an incident report need to be filled out?
Yes, an incident report should be filled out. It's a report of violence. Remember, incident reports don't contain the name of the individual, so there's a protection for that particular person in the case. Now, their name will be recorded elsewhere, of course, but at this stage, that name is protected for that. But yes, any threat of violence, no matter where it comes from, requires an incident report. Even if you had students who are committing violent acts at school, those require incident reports also.
Okay, and in regards to private threats in social media, does this include sexual harassment or is that separate?
There hasn't been a breakout of sexual harassment in this, but harassment is harassment, and harassment can be violent. Harassment, if it's perceived as a violent, threat, that's the one piece. Any harassment, they have not defined which type of harassment can use a TRO. So if someone's feeling that they're being sexually harassed, the 65-year-old that's calling the person, 100 times a day, the company, and some of it has to do with, I want to go on a date with you, I want to send you flowers, that can be equally as part, remember, sexual harassment involves a lot of different aspects. The quid pro quo, it can be direct, lots of things. So yes, you could consider a sexual harassment as a possibility of filing a TRO.
Okay. Thank
Yes.
you for the information. All right, so getting back to our polling question, we kind of took a little segue there, but I'm going to go ahead and close this poll and share it with you. 56% said good. We've got 24% say average, 8% say not sure or no plan, and 5% say excellent.
Well, that's pretty good. That means that most people have their plans. You're rocking and rolling. You're doing great. That's great to hear. And for those of you that don't have your plans yet, hopefully you've heard enough today to get you going. All right, another question for you.
Okay, next one is, do your managers know how to handle workplace violence incidents? The options are yes, they are trained and ready to respond. Somewhat have basic awareness but need more guidance. No, not prepared to handle incidents, or the last one is not sure. And while we're waiting for people to vote, we have another question. What if we work in a property management company and a tenant threatened the property manager with violence? How do we go about dealing with a tenant who lives there and a property manager who works there? More so if this is problematic tenant, if it is a problematic tenant.
Yeah, well, you're going to have to de-escalate. Well, I don't know what you're going to be able to do with the situation, but if that's an ongoing problem and there's a threat of violence between a tenant and an employee, the role of an employer is to protect its employees. So you've got to take steps. Now, maybe there are some other methodologies you could put into place. Maybe there's a counseling or de-escalation, or there's some other methods to deal with. You may not be able to get a physical separation because they got to be in the same environment. That's one you got to really think through. You're obviously not going to just lean towards getting rid of your tenant because you have other rules associated with that. But on the other hand, you're responsible for protecting your employee in these circumstances. So it may be that the employee and the tenant, there's another employee that can deal with that person, or there are, an intermediary when they're dealing with each other. There's someone else with them. You're going to have to come up with a way that de-escalates those circumstances. It's complex, but I would open up, your minds to figuring out how we can minimize these circumstances. Again, could be a simple mediator who comes between the two people to work things out. I don't know completely.
Thank you for that. Okay, so moving on, I'm going to close the poll. We've got 63% that say somewhat. We've got 24% that say yes, they are trained and ready to respond. 6% say no, not prepared, and 6% say not sure.
That's super. Great to hear. That's good to hear. All right. Everyone probably has seen this before, but if you haven't, there are 13 core elements to the Workplace Violence Prevention Plan. These are listed here for you. So if you have a plan that you're working on, now the templates that OSHA provides, they have 16 elements, but they're a little bit convoluted in the way that they put them together. These are the 13 core elements. And then I've broken them out for you to have so that you can see which ones are and what they actually are. And they don't match up perfectly with what you might consider your injury and illness prevention plan, because there's other aspects of this that are included, as part of this plan that are not part of an IIPP. Remember that in your responsive parties, you can use either names or job titles. Nothing's changed on that yet. So if you have a workplace violence prevention coordinator, you don't have to show their name. You can just say that your coordinator handles it. Maybe it's HR, maybe it's risk, maybe it's safety, maybe it's somebody else. So just know that you can use either. And then you've got to have a way to actively involve employees. And I've got some examples in here of how you can use some workarounds for that. 5 through 7 is the compliance. You've got to make sure employees comply with this. And just like in an IIPP, you've got to have things like training, you've got to have discipline, you've got to have, ways that recognize people for really taking a good part of this. You got to have communication. You got to have a methodology in place so that incidents can be reported and that they're investigated. And a lot of you probably already have emergency response plans, but you have to have the ability to be able to deal with these cases that could be emergent. Training is very similar to Cal OSHA, the hazardous inspection and assessment. Remember, this is not your general inspection form. This has to be all the hazards related to workplace violence. And Michelle will provide a multi-page workplace violence hazard assessment inspection checklist as part of our today's presentation. Just remember that if you have a particular type of operation, you may need to modify your form to be able to adjust to the differences in your operation. You got to have a way to correct hazards. You got to be able to respond to incidents when they occur. If it's a non-emergent, response, you've got to define what that is. It's HR that asks the questions, it's HR that follows up. If you're a small company, maybe it's the CEO or the president. And then unlike your IIPP or any other plans in California, you've got to review this at least annually. So if you put this into place in July of 2024, you've already had one review, perhaps in July of 2025, and you'll be looking next year to do another review, depending on when you've put your plan together and developed it. It's good to note that on your plan so that you can identify when you've actually reviewed it. Cal OSHA looks to make sure that you're going to have at least an annual review. And then we're also going to include the violent incident log so that you have that in Excel if you don't already have it. You've got to record all of your workplace violent incidents, and there's a whole methodology behind that. Know that you've got to keep your records for 5 years, 1 year of training. And remember, if you have a workplace violence incident, you put it on your log. That's great, that's easy. But let's say someone comes and says that, now it's 2026, and they say, well, this happened in December of 2025, or this event occurred in October 25, and it's January now 26. When do you put it on the log? Excuse me, the event did occur in 2025. You want to add it to the log. Remember, just like an OSHA 300 log, you update those logs as time goes by. You will do the same with this log. These are the items. 13 categories go on the incident log. Isn't it interesting that 13 seems to be the magic number for Cal OSHA? Now, a couple of considerations. You have your workplace violence prevention plan, but do you have an IIPP? Do you have an emergency action plan? Do you have security measures in place like run, hide, fight? Do you have a crisis management plan, and do you have an employee assistance plan? EAPs are relatively inexpensive. It's a few dollars a month per employee. So if you do have one in place, great. But that allows for an employee to reach out to a counselor. If you did have an event, it's great to have an EAP in place. If you have employees that are struggling, we talked earlier about almost half the cases are suicides. This allows an employee free access to someone to talk to about things that are going on in their life. All right, let's talk about some workarounds before we close out. Now, most people consider the training aspect that it has to be live, in person, and for the employee to be able to ask questions and to be engaged in the process. That's not necessarily true, because there are ways to do this and a workaround, and we have experience with this already in the healthcare standard. And that is, let's say that you want to provide the training online through a video or otherwise, then you can have employees ask their questions and submit them, and they'll get an answer within 1 business day. That's interactive. It's a process that takes place. It's not like being live, but it does allow the employee to have active engagement in the process. Remember, the second part of this is that the plan should be evaluated and reviewed at least annually. And how do you do this with employees? Because remember, employees are supposed to be engaged in this process. Well, we've put a statement in here that's a way that you can do it. You ask for employees to give you feedback, And that allows you to say, yes, we've asked employees to provide feedback on the workplace violence prevention plan. If you get no feedback, well, then that's how it is. If you do get feedback, then you have the chance to integrate it. And remember that you should be doing a threat assessment at least annually. And of course, when things change, if you have a new operation, new hazards, et cetera, you want to make sure that you do the hazard assessment plan. Okay, here's your mini actionable checklist. This is your checklist to take forward with you. It'll be in your package, so you'll be able to go down the list and see, do we have all this in place? If you do, you're probably in pretty good shape. You don't have to go too much further. You'll be one of the lists that says, yeah, we have a good plan and it's in place and everybody knows what they're doing. Here's the things that are recommended to go next. If you haven't done your hazard assessment, time to do it. Remember, we're going to send you one so you have it. If you don't have your incident log, it's important to get that done for 2025. Make sure that you've got somebody that's overall responsible for your plan. You can use the Cal-OSHA model plan. The reason I say it's not a great plan is because it's written like a legal document. It doesn't use your culture. It doesn't use your wording. It doesn't mimic your process or procedures. So just be aware that, yes, it has the 16, the way it's described, 16 categories, but it's not a great plan and it's not going to have your language. So use it if you want, but be aware. And then remember about SP 428 and temporary restraining orders. And then remember to do maybe a quarterly mini review of your program and your plan. So we have one more question before we go and ask you how the session was, but did you have any takeaways from today? And Michelle, I'm going to just open that up. No, we're not asking that question yet. Oh, we're just doing an open question about, has anyone had a takeaway, and to put that in the chat box.
Great, yeah, please do that.
Yeah, so
just quick questions while we're waiting for everybody's
Sure.
response. So one person asked, do all employers need to have an IIPP regardless of company size?
Yes.
Okay, and is the IIPP required for businesses under 50 people? I'm assuming yes. Okay, and then OSHA reporting, do employers have to complete the OSHA logs if you have under 25 employees?
Yes, there are some exceptions to filing the OSHA log. If you go on to if you go to Google or AI, a tool of some sort, you can say, what are the exemptions that don't have to keep an OSHA log? And there are, now remember, this can change. So 1 year, a type of company like restaurants don't have to file. But then 5 years later, it could change because incidents are perceived to be increasing in that industry. So yes, there is a list, both federal and state.
Okay, great. Thank you everybody for your input. It looks like overall everybody enjoyed today's webinar, and we thank you for participating. I'll let you wrap this up, Steve, before if I didn't get to your question, I will be following up in an email because we're running out of time today, but we won't forget you, I promise. And with that, go ahead, Steve.
Well, thank you, everybody. It's been great to be back. I may have been a little slow on the gun here, but I appreciate your patience and being part of today's session. We have the resources that Michelle will upload, and we also have this presentation which will come to you. And of course, stay vigilant out there, be safe, and keep your workplace violence prevention plans up to date. And thank you, Michelle, for being a great moderator. Thank you to a great audience. Thank you. Take care. Any questions?
Thank you, Steve, for your time and expertise today. It was a lot of information. And again, I will be following up with an email. We hope all of you attendees found today's webinar to be a valuable use of your time. Thank you and have a safe and great day.
Thank you, Michelle. Thank you, everybody.